My name's Dennis Tristani, and I'm an immigration attorney based out of the Washington, D.C. area. And I think the important focus of the webinar, and I think what we're really going to get into today, are how long is it going to take based on current wait times for one to obtain their green card, right? I think most everyone on the call has already filed their I-526 petition, whether it was in 2015, 16, 2019. And obviously the step that we're all at now is our 526 has been pending. It may have already been approved. It's probably been approved. We've filed Form I-45 to adjust status. And at this point, the visa bulletin confirms that there's retrogression based on where you were born, whether it's China, India, or Vietnam. And so we're all at the step now where we're waiting for the visa bulletin to move forward and for one's priority date to become current. And again, the priority date being when your I-526 was filed. The presentation is going to get into great detail, not only what that means, but how the wait lists work, why there's actually a wait list in the first place, a lot of which has to do with quotas in terms of how many visas are available to individuals in the EB-5 category, as well as supply and demand of those visas. One more really important point I think that's going to be brought up and discussed in detail is processing times. There's the biggest factor in my mind currently, which is why we're seeing retrogression in the India category, for example, is that so many petitions were filed in 2018 and especially in 2019, and USCIS's processing times were very, very slow, okay, and still are slow. And what that means is that individuals who've had a pending I-526 for many years haven't gotten to the stage where they're going to be receiving their green card. And now that USCIS is processing I-526 cases and approving them in greater numbers, we're seeing a large host of individuals that are now at that green card stage. They're ready for their green card to be printed, for a visa number to be pulled. And because of the country caps, because there's only a limited number of visas per year, we have a backlog. In a nutshell, I think that's what we're going to be covering. Suzanne is going to go into great technical detail on how this process works, which is not only interesting, I think it's important to understand. And then after that's over, we'll be taking questions from the audience, and hopefully we can clarify any doubts that you have.
Okay. So hello, everyone. Thanks for joining. I think most, if not all of you are AIIA members. So first of all, thank you all so much for your donations and contributions. All the money that you have donated all of it goes towards our advocacy efforts. So on the webinar today, we have Suzanne and Dennis. Our real focus today is going to be, as Dennis said, will be on the visa backlog and sort of estimates if you're from a backlog country, when or how soon would your priority date become current. So just to kind of give everyone an overview, if you are familiar with AIIA's immigration process resource page, I've dropped a link of it over here on the left. We are essentially going to be walking through this stage right here. After you file your I-526, all the way up till you receive your conditional green card. So going through this process, which is the, if you're outside the US, which is the consular processing, or inside the US, if you're going through I-485, requires the visa bulletin, the chart, to be current. I'm assuming everyone here is familiar with the visa bulletin, but it is important to sort of understand how many people are in front of you and when will they get their green card, so you'll know exactly when you're getting yours too. So we do also need to acknowledge at this point of time that the processing of the I-526 or I-526E, if you invested after March 2022, is very incredibly slow right now. So that's one of the biggest reasons why you are not getting your immigrant visa in time. So let's talk a little bit about the facts that we have today. So the calculations and assumptions that we're making are based on data that we have currently. The biggest piece of data in all of this was from a recent FOIA request that the American Immigrant Investor Alliance made and then sued over to get, which was the I-526 inventory data as of March 2022. We don't have the data beyond that date. We are hoping to get it, we're actually going to be filing a FOIA request very soon, and we'll have to litigate and try to get that information so we can give you all a better estimate as to what the backlog after the RIA seems to be. So here's a list of essentially all the data that we have used to sort of make calculations and assumptions. And like I mentioned, getting the pending I-526 inventory data is a big portion of that. The other sides of this also is we need to know how many people are registered at NVC, meaning those who are about to do the consular process. And we also need to know how many people are doing in the adjustment of status stage. Once we kind of know how many people are in front of you, it's easier to sort of make an assumption on when you will receive your conditional green card. A couple of assumptions have been made with the calculations. First is sort of determining how many visas have been issued so far and how many visas are actually available, or what is the visa allowance. A lot of times these calculations aren't exact because we don't know what the visa carryover from the other employment-based categories will be. And I apologize if this is getting very technical, but it is sort of important to know that even though we may come up with an estimate today, it's not necessarily going to be accurate because there's so many different variables in play. For example, if you see the other two assumptions, which is your first in, first out processing of I-526 petitions, while USCIS has said that they will do this, we know for a fact that that's not necessarily true. USCIS has been processing petitions out of order, and that causes an impact when it comes to the visa bulletin, because you can have the visa bulletin be current at one point of time, but then change when too many petitions from too early of a date start getting approved. Similarly, there's a length of time that's taken to transfer files from USCIS to NVC. So even if your priority date becomes current and your petition is approved, it takes a long time for USCIS to send your file to NVC, or for you to do adjustment, and then for the visa number to be taken up. So there's a lot of different variables that comes into this calculations, which we can't, necessarily get a better idea of.
The first in, first out processing is particularly important, and I think it has a lot to do with why we've seen shifts back and forth in the visa bulletin. When your I-526 arrives at USCIS's doorstep, so to speak, it's put in a queue. It's put in what is a line to be adjudicated, and it will eventually land on an individual adjudicator's desk who will review it and will either approve it or issue a request for evidence. Obviously, it makes a lot of sense that USCIS should be approving cases and looking at cases based on when they arrive at USCIS's office. Unfortunately, that's not the case. And I can say from personal experience, I've had clients who filed 6 months to even a year ahead of other clients, and they've had their case looked at and adjudicated beforehand. And there's not, there could be a good rhyme or reason for it. I don't want to really get into the details, but some projects are looked at first, and sometimes you have cases where investors in one particular project may see their case adjudicated first if one adjudicator is looking at all I-526 petitions based on one project. And again, these are assumptions attorneys can make, but USCIS isn't going to confirm or deny these assumptions. And so what happens is that you have individuals that get to the front of the line first. They're able to file their 485, or they're able to pursue consular processing in their country of origin, and they're able to take a visa number from the visa, from the pot of visas. And that will necessarily affect how many visas are left over for other individuals that are still waiting for their case to be approved. The last point is a point of not only great contention, but something that's incredibly frustrating for clients when it takes 4 to 5 to 6 months for USCIS to literally transfer an approval notice to the NVC. And while USCIS will claim that there's internal processes that they have to go through for this to occur, writing to the NVC, and I do this on behalf of my clients all the time, most of what we hear is that USCIS hasn't transferred the petition to the NVC. And so there's clearly internal issues that go on at USCIS that some cases are forward timely, some aren't. And I know of colleagues who have had to sue USCIS simply to get their approved petition forwarded to the NVC so consular processing can begin. And it's an incredible inefficiency, and it delays the process. It delays starting consular processing from 2 weeks to 3 weeks after your petition is approved to up to 5 to 6 to 7 to 8 months later, which obviously slows down the process of issuing visas, and because of that affects the overall pot of visas available to individuals.
Okay, so just a reminder on the why is the process taking so long, there are two separate factors. One is just the process constraint, the fact that both the Immigration Service and Department of State have had staffing problems, capacity problems. So, and the fact that there's a multi-step process with first you have to wait for the I-526, then you have to wait for your file to get transferred, then you have to wait for the visa interview. And these constraints can affect anybody. So even if you're from Malta or from another country that doesn't have any visa availability problem, there is a delay for the visa for various reasons. What I'm talking about in my presentation, though, I'm just going to look at the visa availability constraint on the process. And this comes from the fact of limited visa numbers, and especially the country cap that limits applicants from individual countries to a limited number of the total visas. And the country caps affect specifically China, India, and I believe Vietnam, although in our preparation for the call with Charlie, I learned some new things about the Vietnam situation, so I'm not actually sure that Vietnam is in this category anymore. But anyway, definitely China and India are affected by the visa availability constraint in EB-5. And I'm going to go through and look at two ways to kind of try to quantify what we're looking at as far as timing. So when we're thinking about, here's my priority date, when can I expect a visa to be available? There's the answer, what's the wait time? And the equation that we look at is, first of all, thinking, well, how many people are ahead of me in the queue with earlier priority dates? And then at what rate are visas going to be issued to my queue? And this calculation depends on assuming first in, first out, both at the I-526 and visa stage, which is kind of an extraordinary assumption, but that's what we have to assume. So what we try to calculate is just those number of people in line and then the supply that's going to be available. And this slide kind of illustrates what is the situation as far as the number of EB-5 visas available that we're looking at since the new law was passed. And one thing that gets confusing to people is that it's not an exact number of visas every year that's available. It's a matter of percentages, how many people in EB-5 end up getting. So we start out with a total number of employment-based visas, then EB-5 get its a percentage share of that. Then EB-5 share is divided up into the rural high employment infrastructure reserves, which are just reserved for people who invested after March 2022. So everyone who has priority dates before that is in the 68% unreserved. And then within that, people from any one country can only count for sure on getting up to 7% of that number. And so as far as the sheer numbers of visas available, in a typical year, EB-5 has 140,000. So that leaves about 10,000 for EB-5, which leaves about 6,800 for unreserved, and then just under 500 per country. So that's the kind of visa availability limit that we're looking at. So people from India are competing for one of about 500 visas a year in a normal year now, if they're in the unreserved category. China can expect more than that because not every country wants 7% of the EB-5 visas, and China, they're the oldest priority dates. They get the ones that are left over. But you can see why there's a supply problem in EB-5, just because once you slice and dice the pie down to the 7% that people can get under country caps, it's not that many visas. So people who invested after in the new rural category. If they're from India and limited to 7%, they're competing for one of just about 140 visas a year. If in the infrastructure category, that's only about 14 visas a year. So with only 14 visas, that's accommodating, maybe only 5 investors, because when you think about the investor plus their family are going to come in. And this chart is important to look at for people who are on the public policy side and realize why EB5 really needs visa relief, because this is not much of a market. And it's obviously a concern for people who are already in the line thinking how many visas are available. So once we've thought about, okay, how many visas are available, then how many people are in line for those visas? And as far as counting up that line, there are 2 places to count. One is people who are at the visa stage. The other is those who are still pending at the I-526 stage. And to count up people, the visa demand that's associated with pending I-526, we take the number of pending I-526 and then multiply that by assumptions of how many people are going to get approved, make it to the visa stage. And then visas per principal, we want to calculate in, this is where we add in the assumptions about family size. And then counting up people at the visa stage, we want to count the people who are registered at NBC, count up the people who have I-526 approval and I-45 pending. And then also remember that there are some people who are at any given moment just sort of in no man's land. They've got I-526 approval, but they're waiting for their file to get transferred. So these are the people that I want to count. And the cells that are highlighted in orange there are what we have data for as far as what's the fact. And some of the others are either a matter of guesses or assumptions about what's going to happen in the future. And so just to give a little example, and this is actually the calculation that we talked about with Charlie when we were preparing for this webinar. So let's take an example of Indians who applied in March 2022. We know, thanks to AIIA's FOIA request, that there were 2,175 Indian I-526 that were pending at USCIS as of March 2022. And we know that there were about 1,900 Indian applicants registered at the National Visa Center as of that time. So let's then try to count what is the size of this queue as far as visa demand. And here's a rough way to make that count. So we assume those 2,000 I-526 pending, about 3 visas per investor, then add that to about 2,000 at the visa stage. Okay, we've got about 1,000 Indian EB5 applicants. That's sort of a rough and ready way to make that estimate. So let's plug that into our equation here. If we've got about 8,000 Indians in process and about 500 visas a year available to them, 8,000 divided by 500, that's about a 16-year visa wait. And you look at this equation and it's just so long. How is that possible? And you start to think about, well, what if? And there are a lot of exceptions. For example, you see that 500 visas average a year assumption. That's a base case, just assuming the normal year. But there are abnormal years. For example, last year in real life, Indians got over 1,300 visas due to some unusual circumstances. And so what if we sort of rerun this calculation, but try to account for things that are unusual, or thinking on the demand side in that sort of rough calculation, we were assuming 3 visas per investor. But wait a minute, a lot of Indians are smaller families. They're not taking that many visas. So we'll do a second estimate that kind of tries to incorporate those nuances. And so, for example, on the supply side, we've got the baseline of visas that comes down to the minimum number of employment-based visas available every year. But things can and do change that. For example, some years having a higher employment-based visa limit. That happened last year because EB got a whole bunch of extra numbers from that went unused in family-based. In the future, there will be carryover probably of unused reserve visas into the unreserved category. That will give us some extra supply. In the case of China, they can count on otherwise unused visas from the rest of the world to go over that 7% allocation. And then there are some processing issues as well. So I'll just give the example of this year in 2023. EB has an unusually high annual limit again, thanks to unused family-based. And so this year, each country in the unreserved category is actually getting a little over 600 visas. So that's the example of the exception this year. And so if you really want to try to manage sort of a granular calculation for visa supply, you do it 1 year by 1 year by 1 year. And so every year we've got this base number. But for example, in 2022, Indians got over 3,000 because of extra EB visas and some that were just as a factor of processing. India got extra visas. I expect that this year, the next year, and the year after, India will also be able to get some extra visas. So if I had to make a guess, just based on rollover of unused visas and so on, I would guess that India will probably get at least 700 visas as an average between 22 and 2030, if you average across what they get year by year. And we can also add some nuances into the demand calculation. So we've got, again, in those orange cells, the facts that we know. We know how many I-526 were in process. We know how many were registered at NVC, but let's add some assumptions about how many visas are actually going to come out of that. And so what I put in here is historical numbers on how many Indian I-526 got approved how many Indian visa applications got approved. This came out of a GAO study. What has been the actual historical average of visas per principal for India, which is actually historically rather low. And so rerunning with those different assumptions about how many visas are going to actually come out of the demand that's already in process, that comes with an estimate, oh, maybe it's only more like about 5,800, I guess, visa demand that's going to result from the number of people in process. And rerunning that equation with these modifications, modified assumptions on approval rates and attrition, modified assumptions on how many visas are going to be available. Here's an estimate that will come up for an Indian with the March 22 priority date. It's looking at, well, that would take 8 years to issue visas to that many people. And I can still look at this equation and say, wait a minute, this could not be right. This can't be realistic, because who's going to wait 8 years just to get conditional permanent residence? People weren't expecting to wait that long. And so to really get kind of a real life estimate, another way to think about it is just start at the end and go, okay, how long can people stand to wait? If people can only stand to wait for 4 years, then we think about what has to happen on the other side of the equation to make that possible. And so either we need to get more visas available or people are going to drop out. I think that's the fact. And so that's something to think about and work toward on the public policy side, is getting more visa availability and or at least making the wait time more tolerable for people who are in line. This here is a chart just, again, illustrating this, kind of summarizing the estimate 1 and estimate 2 that I went over, where it starts with the same facts: how many people have pending I-56, how many registered at the National Visa Center, and then in the second section, applying different assumptions about how many of these people are going to make it through the process, what's the family size going to be, and illustrating how just changing those assumptions results in very different estimates on how long is it going to take. And I do this in a giant Excel file. Ishan is currently trying to turn my giant Excel file into a web tool where there will be sliders. So you can enter priority date. It will, based on the facts we know about the priority date as far as how many people are in line, and then you can do sliders on different assumptions on attrition rate, family size, visa supply to sort of play around with the estimates. And I also have an example here for China, where estimate 1 is kind of the base case, which we worked on with Charles Oppenheim for this presentation. And then estimate 2 is one where I tried to add nuances on what could be a more best case on visa supply for China. And entering in some historical numbers on I-526 approval rates and visa stage approval rates. And that also comes up with very different conclusions on what the visa wait outlook could be for China. And so all of the estimates that I did before were just for somebody who's at the end of the line as of March 2022 when the law changed. But for people who are not at the end of the line, they're somewhere in the middle, how can they calculate where they are? And the key there is just to come up with the number that we can enter in that green box there for the demand. And this is something that I've done on my giant Excel sheet, just piecing together inventory data from different Freedom of Information Act requests to figure out if you're an Indian and you applied in June 2018, where are you in the queue at this point? Or if you're Chinese and you have October 2016, where are you in the queue? And to just sort of visualize the logic behind it, these two charts here plot I-526 filings for India and China. And looking at these charts, you can see that people really have not entered at an even rate. There has been big filing surges. And if your priority date is to the left of one of these filing surges, obviously you're in a much better position than if your priority date is to the right of one of these filing surges. And so, for example, in India, which is the first chart there, that line that's going way up into the sky is November 2019. A lot of Indians filed on that date. So if you have a priority date before November 2019, you're in a much better position than someone who has after that. And for China, the bar that's highest there is for the quarter July to September 2015, which helps explain why it's taken so long for the visa bulletin for China to make it past September 2015, because that's just a lot of people to process. And you can see how the demand has been dropping off more after that.
So guys, this is something we are working on. It's not ready yet. I don't know how accurate the results are, but so I'm a little nervous and apprehensive to show this to you all, but this is a tool that is something that's going to be accessible to AIIA members. As of right now, you'll see the priority dates are somewhat limited. We're only allowing specific priority dates to be calculated, but I do want to give everyone an idea of sort of what to expect as you if you were to use this. So taking the example of March 2022, and for India, assuming an approval rate of say 60% with approved visas, with people making it through the NVC or the I-485 stage at least say, let's just make this 80%, and with say a petition of usually around say, let's go with 2.5 for this. Someone say who's invested in March 2022 could possibly get their green card here or in 2025, assuming these numbers. But in reality, if we look at say to the worst case scenario, assuming say everyone in front of you, if you invest in March 2022, everyone in front of you gets, all 100% people get that approval. And along with that, everybody makes it through the I-526, the 485 and the consul processing stage. And let's just say, lots of people are having babies and, there's more people on the petition now. And we say increase this to say 2.75. Now that number has drastically increased. And this is just for say India. Now, if we look at China, for example, I know we have somebody on this call with a May 2016 priority date. So I'm going to take his example. If we assume that, say, out of all those petitions that are remaining to be adjudicated in front of the May 2016 investor, and they get approved at a rate of 60%, average will say everybody in front of them who's got an approved I-526 also goes to the consular processing and the adjustment at 80%. Approval rate, and the average demand is 2.7. That's not too bad. I mean, that's basically in the next 2-3 years, their priority date should become current. Now, when they'll actually get their conditional green card, will they actually get it on this date? Now, that's really kind of debatable. There's a couple of reasons why this estimate is not so accurate, because this could assume that the priority date becomes current in this fiscal year. For that individual to now actually move forward, go to the consulate, do the interview, get the green card, there could be a lot of issues along the way. So for example, let's just say if Guangzhou consulate is not issuing enough visas in time, then that person, whether he's sitting in the US or is sitting in China, it could take him a long time to actually get his green card. So I guess on that note, it's probably worth sort of discussing, more country specific issues and why these estimates aren't exactly accurate.
If you look at these charts of China I-526 by period and India I-526 by period, you can see why we expect that China will basically have the priority to use the visas that go to the older priority dates for the foreseeable future, because the China surge kind of stops right here in late 2017, early 2018, just as the India surge begins. So Indians have to wait for all of these Chinese to get through the system before they will start to be the oldest priority dates and in line to get the otherwise unused visas. So when I try to make my estimates, which I think is the assumptions that Ishan sort of put as the base case in his calculator, I am assuming that for this decade, the otherwise unused visas are going to be going to China, because China will be the oldest priority date through most of that period. And I'm also making pretty optimistic assumptions for China, because I'm assuming that now that we've got the new reserved categories, that new people coming in are going to be applying in those reserved categories. They're not going to be applying for unreserved visas. And so unlike in the past, when people from China had to do a lot of calculation based on incoming demand, how many people are going to be sort of continually decreasing the pool of visas available to me, I don't think we're going to see that as much now. We have to account for the rest of the world who already invested before March 2022 to get visas. But once they're out, I think that's going to be more and more visas available to China, which is why the estimate in my estimate for China was so much lower than the base case that Charlie illustrated. And it's based on the assumption that China is going to be increasingly have more of the unreserved visas available.
So talking about specific issues now, like why it's hard for us to estimate exactly, what the results will be. Keep in mind that the calculator only actually estimates when the visa will be available. When it will actually be issued to you, now that depends. Also, like we don't know if say, for example, the visa bulletin will actually reach that stage, because there could be people ahead of you in line that haven't got their visas yet. So, for example, in the scenario with China, that heavily relies on consular processing. If the consulate does not actually issue enough visas in time, that priority date to reach you might take longer. Not to also mention that, we could also have people who will drop out, hence lowering the time it may take to reach you. Kids could age out. We don't know how many unused visas number could show up in this category. If we don't know if it could get less or more. So making some of these estimates makes it a little bit harder to do. Similarly, so for India, for example, a lot more people do adjustment of status. So likely when we get updated numbers, we're going to have to try to focus on USCIS to actually give us those numbers of who all are at California Service Center, etc. There's also a large number of Indian petitions, and similar with Vietnam as well, there's a number of Indian I-526 and Vietnamese I-526s which are still pending from priority dates that go far, far back. So if now those priority dates, those petitions start getting approved, then you could have a scenario where those investors need to be issued their visas first, ahead of you, hence increasing your wait time even more. And then, of course, the fact is that Indians and Vietnamese are still newer to EB5. So there could be a scenario where many of these families have more kids or people get married, and essentially the number of visas given out to Indians and Vietnamese investors could be a lot more than, say, what may have been estimated earlier on. So hence, that's why with the calculator, we're giving you the option of using the sliders, so you can really kind of come up with your own hypothetical scenario on how this could play out. Obviously, there are things that we can't take into account, which is, such as not being issued enough visas, if the country cap isn't reached every single year, etc. We also can't anticipate people could be denied at the I-526 stage or the consular processing stage for random reasons. So that's why it's hard to like exactly say, and I keep saying this over and over again, it's hard to estimate exactly when certain priority dates could become current. Our tool just does an estimate based on the math we have available.
And I'll give an example. In 2018, 2019, I actually offered a service where I helped people to calculate potential wait times. And I felt pretty good about the math. I did not predict that there would be a global disaster that would shut down consulates around the world for over a year. This just did not even occur to me that this could happen, and it happened. And this had a huge impact on EB-5 wait times. So that's an example of the kind of thing that can happen. And also the fact that the law can change anytime, which we are experiencing right now. 2 years ago, at the time when many people invested, there were about at least 700 visas a year available per country. That's been reduced by the new law. The law will change again in the next 4 years. We don't know what that will do to visa availability. Hopefully with AIIA advocating, we'll be able to get a better visa situation rather than a worse one. So another thing to keep in mind.
We have a slide now to just sort of talk about potential solutions to the visa number problems.
So there are a couple options when we're talking about changing the law and how we can sort of seek out legislative solutions to fixing some of the visa backlog problems. So what seems easiest and most rudimentary is just making more visas available to the different EB categories each year. So the minimum annual limit is currently 140,000 per year, and EB-5 gets 7% of that. So obviously, if that total is increased, then EB-5 would have a few more visas to play with when they're issuing per year. But that's a little bit of a harder solution, just given that increasing the total amount of visas to the immigrant population may be like hard for Congress to agree to. It's not necessarily a bipartisan option. The second option is removal of counting of derivatives. So for the EB-5 program, essentially all family members that are listed on one petition are counted against the EB-5 visa total for the year. So if one petition has, say, four family members, 3 kids and a spouse, then that's 5 visas that are then taken from the total EB-5 pool. If only the original EB-5 petitioner, so the main applicant, was counted against the EB-5 visa pool, then there would be far, far more EB-5 visas available each year to different petitioners, rather than them being taken up by one family with many children or people who are adding spouses, children to their petitions. Not that there's anything wrong with that, but it would make it easier for that pool to be distributed amongst a larger group of people. Another thing is removal of the per country cap. So this is a little bit of a divisive issue. It makes sense why applicants from backlog countries would see the value in removing the per country cap. However, we think that removing the per country cap really would not do as many people justice in getting their petition approved. It would essentially shove everyone, regardless of country, into one line, and it would harm people who have been waiting for a really long time. So it's not necessarily the most viable solution, but what our team agrees is something that is very viable is something called visa recapture. So visa recapture is a process that Congress has used many, many times before, where they essentially look at the past years and all the visas which have been left unused and sort of been lost to time as more visas are issued year by year. Congress, what they will do is they will pass a law that essentially says all of those visas which were lost in past years are now available for the incoming fiscal year, essentially making everything that wasn't issued in the past couple of years available for issuance this year and the next year. It's a tried and true process. We've seen a couple bills be brought up this year and I think last year as well, asking for visa recapture and visa relief for the EB categories and so forth. I believe the DREAM and the Relief Act were both different acts which were proposed. So Congress people are thinking about this. It's a very common thing that comes up when we're talking about immigration bills. So we believe that that's one of the most viable solutions for fixing some of the visa backlogs. And then the last one is, of course, increased processing capacity of USCIS and the IPO. anyone who's trying to get a visa interview at a consulate in Abu Dhabi, possibly in Montreal, definitely in Ho Chi Minh City, they're not issuing EB5 visas, and they're not even scheduling those interviews. Those are problems that definitely need to get fixed. And there's structural issues that the Department of State and the DHS will need to issue, or not issue, but like fix anyways in the coming years, given that that's the job of those consulates is to be scheduling those interviews. For processing capacity at USCIS and IPO, everyone sort of knows that USCIS has had staffing issues over the past couple of years, and they've sort of pleaded for relief and used that to justify the fee increase and so forth. So we sort of anticipate that going to USCIS in the Department of State and the Department of Homeland Security, which is the parent organization of USCIS, and saying that these staffing issues have existed for a while. COVID is not as much of a problem anymore, so we need to start fixing these issues. Though that, in conjunction with visa recapture, we think can really make a difference in solving some of these backlogs, or at least relieving some of the stress that they've put on the EB5 program.
Yeah. So talking a little bit about this post RIA numbers, it doesn't look too great, right? When you're looking at something like this. So just to so when you as a post RIA investor are looking at, hey, what could my possible wait time be? Really, the worst case scenario may not exactly be what you want to hear. Let's take, for example, the rural category. So we know with the rural category, there's going to be 139 visas available. Now, even if we assume that
as a base case,
as a base case, right, 139, but we could make this case a little bit better. We could multiply, just take this 140 number, let's multiply that by 2, because let's also assume that we'll get the previous fiscal year's leftover reserve visas as well, say 2022 and 23. Now, when you're looking at a scenario like this, where you know that you and your pool of applicants will have access to 280 visas, if there were, let's just say 300, 400, or 500 petitions from that country, or let's take a smaller number, let's say 250 I-526E petitions from a specific country. Now you multiply that 250 with 2, let's just assume there's 2 applicants per petition. You're looking at a demand of about 500 visas. And when you take that demand, and if you calculate it against the base case, which is just 139, that comes to about a 3.6-year backlog. Whereas if you now add in those unused visas from the previous year, that waiting time just became half. So, and I apologize if it's hard for people to follow along, but essentially what we're trying to highlight when we go over this situation for post RIA investors, it is very, very easy for your country, your specific pool of visas to become very small, to shrink, and to be filled up really quickly. So a backlog in the post RIA process is easy to come by. However, there are other factors, such as will the other countries actually use up all 7% of their minimum visas? Will they will how many unused visas will there be? How many petitions will actually get approved in a specific fiscal year to move forward and get their visas? There are so many unknown variables here that it's hard for us to estimate, but we can make a guesstimate of what the worst case scenario would be, which can be really bad.
Yeah. And the numbers to look at on this slide to sort of think about, are we in the danger zone yet or not for the post RIA investors? One is to look at the total number of I-526E that are coming in and ask, does this exceed what is available in the category? So if there are, say, 1,000 I-526E filed and they're all rural, then we notice, say, because 1,000 I-526, that's going to be at least 2,000 visa applications. 2,000 visa applications is more than rural can take in 1 year. And when you get more, when you exceed the total that's available in the category, that's when the country cap kicks in. That's when individuals start getting limited to 7%. So long as the total demand is under that, then that 7% is not going to be a trigger. And then the other question is, just as you mentioned, how many visas are going to go unused from countries that aren't China and India and Vietnam and be available for those high use countries to take above their 7% limit.
Stephen and Rana have a question regarding this rollover of unused visas. So basically, so as far as we know in the RIA, they do allow the rollover of unused set aside visas. If they're not used in the first year, then they go to the next year. We don't know when they actually give out those visa numbers. Will they start by giving out those unused numbers from the previous years, or will they start with using the minimum reserved ones? It's very hard for us to make that estimate, so we don't know exactly how that will pan out.
When we had our prep call with Charles Oppenheim for this presentation, I asked him about this, and he said if it were he, when he's giving out visa numbers in a given year, if he's giving out a reserve visa, he would hypothetically say this is one of the unused ones from last year, rather than this is one of the fresh allocation from this year. And so if that's how Yoko Horner, who's now at Department of State, actually does it, that could allow visas to roll over within the reserve categories for a long time. If they say we're giving out first the visa numbers that are available within the category for this year, that would make a greater chance for the visas to carry over into the unreserved category the next year.
Yeah. So Ron asked, sorry, go ahead, Dennis.
No, the only other thing I was going to point out, I do think it's also worth mentioning that all of these set aside categories are current, and I think Charlie's gone on record saying that he thinks they're going to be current until April, May, even June of next year. Okay. And so that's, whether or not, and I think that's where I-526 processing comes in. As of now, at least myself, colleagues, I know Suzanne hasn't heard of an I-526E, a post-RIA I-526 petition being approved yet. We don't know how long USCIS is going to take to process these cases. So for at least, the next, say, year or 10 months, assuming predictions are correct, these set-aside categories are going to be current, which is a benefit to certain investors who are in the United States who are able to take advantage of the current, the fact that these set-asides are current and file for adjustment of status. You may have more individuals pursuing this path because they're able to do so. But again, that's also increasing demand and increasing this buildup based on a situation where we don't have a ton of visa numbers in the set-asides. And so I think it's just something worth mentioning, whether or not, when these categories become backlog, what the cutoff date is going to be, because they would have been current for so long.
Yeah, and I think we can look at India as sort of a cautionary tale on that. India was, if you look at the number of I-526 filed, India exceeded the annual limit just based on I-526 filings back in 2018. But India stayed current in the visa bulletin in 2018, 2019, 2020, 2021 mainly because USCIS wasn't processing the petitions. They were just stuck at the I-526 stage. So the visa bulletin stayed current, but the backlog just kept building up and building up, and something we hope we don't see history repeat that way with the new categories.
Yeah, and so Ron asked a question regarding, it really benefiting the 485 applicants, and I think that's what's most likely going to be. I did argue with Charlie on this fact, because Charlie was like, oh, it'll probably won't be current next year or soon after that, and he's repeated that in some other webinars as well. I vehemently disagree with this. I think that if there's going to be a 4-year average processing time, because as of right now, we haven't been told that there will be adjudication of I-526E petitions ahead of I-526 petitions. So essentially, you could have a scenario where lots of folks will do adjustment, they'll get their work permit and benefits, but then there'll be a bunch of people just waiting outside the states, waiting for their consular interview, and then suddenly there's priority dates being announced 3-4 years later. They're waiting for all the people who are doing adjustment to receive their green cards first before somebody sitting outside the country can get theirs. This will increase the immigration times massively. This will also increase investment times. If the sustainment period remains tied to the conditional green card period, then if someone invests in a set aside category, let's just say from a heavily backlogged country, which we don't know is backlogged yet. Let's just take the example of China. Somebody from China invests next year in a rural category where there's already been probably 400 or 500 petitions. I mean, they could be looking at getting their green card 7-10 years from now, from today. So I don't think, unless if you all of you have read Suzanne's previous letter to Mr. Mark, unless USCIS can actually give us those numbers of the monthly I-526E filings by category, by country, there won't be any way for prospective investors to or existing RIA investors to actually know for sure what their wait times could be. AIIA is aiming to get that information and releasing it.
By the way, Sean, Sid in the comments pointed out that the visa bulletin did have retrogression for India pre-COVID, which I'm reminded of now.
Yeah,
it was with the extra visa availability during COVID.
And they ended up actually issuing more visas to Indians at one point, beyond the 7%, I think.
That was just last year. And on the idea of how many unused visas were there, yes, we do know that. I don't know the number off the top of my head. There have been attempts on this in the past, and the argument against it is that technically visas don't just go unused. They wash back and forth between employment-based and family-based. But that is an argument that has been tried and could be tried again in the future, because EB-5 did not use anywhere near its total number of visas for most of its history. And another thing on the processing times is that I do expect I-526 processing times to go down, and I also personally expect that they'll probably have a separate queue for I-526E that will get advantaged in some way that will I don't expect to see 4 to 5 year processing times on I-526E, but we'll see.
I don't either. I share that view. And I guess we'll soon know what priority processing means for rural applications, since that's something in the RIA and something that USCIS has to implement. But it's probably too early to see what that actually means in terms of timelines.
Here's just roughly where we stand, where AI stands in terms of our priorities. We want to solve this issue. Like, we understand wait times are very anxiety inducing for a lot of investors. We are the only organization that's fighting for investors' issues. I do want to highlight that our work is twofold. One is to, of course, increase the annual visa limit, whether through visa recapture or other means. But also we need to speed up the way the EB-5 visas are issued. Even if we get extra visa numbers, it's going to be pointless if the different consulates and California Service Center isn't issuing the green cards quickly enough. How do we make that happen? Our hope is to lobby for it. We are also potentially planning a lawsuit against the government agencies, but in this particular case, with the results that we want, we believe that lobbying is truly the best way to go. So for those of you on this call, we obviously appreciate any support that you can give us, whether it's in the form of further donations or encouraging your friends and other clients and other investors that and have to join us, become members, volunteer with us and things like that. So yeah, I think all of you already know my spiel on this. So with that, we can hop into Q&A and sort of and go from there. So we have a question from Radhakrishna. From outside the US, as adjustments are happening quickly for people inside the US, can we apply for H-1B while I-526 is still pending? And okay, so the question is that I think this is a question for you, Dennis, is if you're sitting outside the US, can you come to the US on a non-immigrant visa, hopefully the one that's dual intent, and adjust even if the I-526 is still pending? You can.
So under one of the biggest benefits of the RIA and the changes are, the ability, if your priority date is current, you can file for adjustment of status based on your pending I-526 petition. I would never advise my clients to come into the US on a tourist visa, for example, and adjust very quickly. You always want to wait 90 days. At a minimum, if you're thinking of adjusting status after having entered on a tourist visa or even a student visa, but 100%. My firm filed many of them last year post RIA, and it's allowed many of my clients to get their EAD cards, to obtain travel permits if their non-immigrant visas weren't valid anymore. So it is a possibility.
Wait here. I'm gonna let Rana speak if she wants. So Rana asked, is any idea do you have on insight when USCIS will finally implement priority processing or rural in the RIA? Dennis, Suzanne, do you guys have any insight on that?
I mean, I don't want to say it's anyone's guess. They should already be doing so. Rule cases are being filed, over the last year. I think I mentioned on a previous article, maybe 4 or 5 months after the RIA came out, and I said that, my hope was that priority processing for rural cases would be, a year, maybe a year and a half at the very, at the lengthiest, only because processing pre-RIA for I-526 petitions was, in and around 2.5 to 3 years, which was still very long. But I think that's when a bulk of cases were being adjudicated. Obviously, some way before, some way after, you have outliers, but USCIS's policy goals are to eventually adjudicate I-526 cases in 6 months. That number seems absurd almost, but that's what their stated policy goal is, which is supposed to occur in 2 to 3 years from now. So I can only imagine that rule cases should be, well below what normal processing would be, but they haven't gone on the record to say what that means, what that pace is going to look like. But it's in the statute, it's law, and so they do have to prioritize them. But what that actually means, given the fact that we're only about a year out in terms of post RIA passage, I think we just don't know yet.
A couple things to say on that. One thing is that the I-526 time, there's part of it that's touch time, or it's the file is sitting on an adjudicator's desk, but the vast majority of the wait time is just queue time. It's just time sitting in the warehouse waiting to even be put on the adjudicator's desk. And when I think about how could they possibly give priority processing, the only way I can really visualize it is if they just say, okay, we're skipping queue time for this. We're not going to leave it in the warehouse first in, first out. We're just going to stick it on the adjudicator's desk. So if that's the way that they do the process, that could be a very considerable advantage. And the only thing that I've heard come out of USCIS related to this is that I look at all the job descriptions when I hire new staff, and they posted a job description for new office assistants recently, where one of the job descriptions was to be able to do intake and recognize if a file qualifies for priority processing. And so that tells me that they are planning to just at the intake to do a sorting. Does this qualify for priority or not?
That's interesting.
Yeah. So Rana says that they will create a specific division for rural priority processing division. I don't know.
I was talking to a large regional center operator the other day who said that in her observation, it looked as if their I-526 were being adjudicated by people who are in charge of an area. So they could see that I-526 for one area were getting done by a person who had specific characteristics, and one by another area were done by someone else. So if they're already dividing adjudications or allocating by area, that would be rural would be easy to fit into that.
Mm-hmm.
Although on the other hand, like it would be really unfair if that were to happen, right? Because you're basically saying that if somebody invests in a rural project today, their I-526 would be approved sooner than, say, someone even from a non-backlogged country who's applied for an I-526.
Oh, well, yeah. I mean, that's the whole concept of it, is that it's unfair.
Mm-hmm. And it's unfair to people who invested in a rural project pre-RIA, who if which, I think that's why you do have some people withdrawing and reinvesting, just to take advantage of post RA rules.
Yep.
Dilip asked a question earlier about like them processing petitions based on availability of visas. How much do you guys think that might influence anything?
I can say for China, I think that has a huge influence. And the influence is that petitions that have to wait for 5 years to get adjudicated are twice as likely to get denied as ones that are adjudicated promptly. And we've seen the I-526 denial rate for China go from almost 90% before they implemented that rule to less than 60% in recent years. Part of that is the discriminatory policies they've had on China's source of funds. But I think another important factor is just the sheer number of Chinese who have dropped out and given up because they just had to wait too long for the adjudication. So that's one thing I see, that their visa availability approach to I-526 processing reduces the queue.
Yeah.
Yeah, I agree with that. Whenever I push USCIS via email for a client, either for an adjudication or if it's another issue, I always remind them of the approach they're supposed to be using, and they acknowledge that approach every time they respond. Part of me always wondered whether they're actually following it, but I wholeheartedly agree with Suzanne on the China issue. I think that's exactly what's happening.
If anybody has any more questions, or if anybody wants to unmute themselves and speak up, you use the raise hand feature. I do want to quickly just I want to show one slide that Charlie and us worked on, which we never ended up publishing, just for those of you who are on the call and all curious about it. But this is what you see on your screen is an estimate based on the numbers that we calculated. It's similar to what you might have seen that Charlie has presented in other organizations, but if you are looking at a March 2022 priority date, this is what your worst case scenario or a scenario looks like for you to get your green card. This was based on Charlie Oppenheim's calculations, and this is using the same.
This was the estimate one that I put in my presentation.
Yeah, so you can tell it's not the best. With the rest of the world, you're really just looking at sort of, I guess, processing times and everything that comes into play. But for Vietnam, India, and China, the situation is pretty grim. And of course, we expect it to be better than this, given the fact that there will be denials and there will be people who will drop out, etc. But at the same time, it could be these numbers could actually be accurate because of slow issuance of visas in line. So yeah, this is what sort of the situation looks like.
And that is specifically for the unreserved, for people who filed before March 20, or people who filed on March 2022.
Okay, I don't know how many people are on this call from countries other than India, China, Vietnam, the usually backlogged countries. For the gentleman from Malta and other people from non-backlogged countries, their visa timing is going to be determined by the processing time, not the availability. So can you say a few words about how you see the processing time shaping up in the next year, 2 years, whatever? What's going on in the processing?
On the I-526 side, the two factors I see: on the positive side, they are hiring a lot of new staff. On the negative side, they are diverting an enormous amount of energy to non-adjudicative tasks to implement RIA. So I'm expecting to see improvement, but not enormous improvement. For example, we've seen them going from about 100 I-526 decisions a month to about 200 a month, but we need it to be more like 1,000 a month. So it's an improving trend, but I'm not hugely optimistic. And Dennis?
Yeah, I agree with that. I mean, personally at my firm, receiving some approvals. We're receiving RFEs, we've, for project issues, recently what I've seen, which used to be a trend that I was seeing 4 or 5 years ago, is USCIS is issuing requests for clarification, which is a simple email tool they use where they ask the attorney of record provide either a simple source of fund document or maybe an updated TA letter or project document that got lost in the shuffle. They're giving you 10 days to do so online. And fortunately, they're responding very, very quickly to those emails, and they're issuing decisions based on the response that's given. And so I always thought that requests for clarification were helpful in the sense that if you got one and you were able to respond to it for your client, you could expect an answer. It was almost as the adjudicator just wanted to get something over with and approve the case. They just needed a box to be checked. And so I am seeing requests for clarifications issue more, and I know other colleagues are as well. So I think that's a good thing. It's definitely a positive thing.
Yeah, going back to that topic about how you said, I mean, I too have sort of seen a few more approvals and adjudications and a little better trend, but there was a point where they were approving about or adjudicating about 1,000 a month. That was around what, 2018, it shifted, right? And the huge shift down, it went down to about 100 a month or something. And it was a major change in the policy at the IPO. And of course, we had a new, at that point, head of the IPO. What happened? I mean, right? We went from 1,000 a month to 100. I mean, it was a huge shift in how they viewed the entire division and their mandate, and it became a security thing. And then they haven't moved away from that because all the adjudicators moved into different roles. Is there anything that can be done? I mean, they don't view their role anymore really as adjudicators, it feels like. I don't know. And obviously they have a new head of the division and have been for more than a year now since they are, since the RIA. But the question becomes, why is it that it shouldn't take the number of hours that it clearly supposedly is taking them? And they've increased the number, they're proposing an increased fee for the I-526E, and then when they do it by claiming that it's so many hours, man hours in order to adjudicate, a single petition. And yet then they later don't use those number of people, or whatever to adjudicate. I mean, what is it that can be done to get them to start using the people that they have to actually adjudicate so that they start going back and doing the 1,000 petitions a month? Is there anything?
One thing, AIIA found out through Freedom of Information Act request how many people they had assigned to adjudication. And I think that this is very powerful information for anyone who's litigating, just because one factor in 2018 in the present is they halved the number of people who were assigned to adjudication, even as their total staff remained the same. So that was a major factor in the dip in productivity. And then the second factor, they had a so-called reset training in mid-2019 that did change their adjudication policies and reduced deference and so on. And I would love to see them revisiting that training and new practices and worksheets and so on that they implemented that were kind of part of the so-called extreme vetting philosophy that was current at that time and should no longer be current.
Okay, so they went from 57, 67, 56, 35. So they did have a big drop, 20 less people between one quarter to the next, right? Between 2018, 2019 to 2019, 2020 on the I-526s. But then the reset training, what was that?
It was a training that they had in May 2019 for I-526 adjudicators and later in the year for I-829. And that's when they implemented the sort of pick through every little straw approach on the source of funds analysis. We saw deference to prior approvals pretty much go out the window after that. And they had different adjudicator worksheets implemented at that time that I think we saw reflected in the different RFEs. And so far as I know, they haven't done another training since then.
And none of that was based on any new regulations or anything. It was just shift in policy on their part.
Yeah.
Mm.
And we just learned this, right?
I think AIIA got that training via FOIA request in 2020, I think. I was actually in communication with an IPO adjudicator at the time who tipped me off on the training and suggested that the industry should FOIA that because it was some significant changes.
Oh, I did not realize that. Huh. Yeah, no, I mean, it's just interesting information. It's too bad it was during a certain time because I don't know, it seems that significant shift in, the policy is, is more than that. It's too bad. As an industry, we didn't react more.
Hmm.
Yeah. But yeah, they dropped 20 adjudicators from 2019 to 20.
USCIS systems are hopelessly poor, as I have written. A lot of people don't understand this or realize it. Paper filings, you can't implement FIFO, petitions are stuck in warehouses, just left to chance. No wonder they take 6 months to transfer the approval from USCIS to NVC, something that can be done in an electronic click. What can people outside do? We can just all wring our hands, of course, but can we do anything else? That includes AIIA, all the lawyers, AIIA, AIIA, different RCs. Everybody has a joint stake in this. Maybe nothing. I don't know. I was just wondering.
I think that one thing that has had some effect is just shedding light on the situation. Because, for example, in the, I forget if it was Freedom of Information Act or litigation that revealed in mid-2020, they were down to only like 15 people assigned to I-526 adjudication, that people reacted very strongly to that. And there were like 30 more assigned the next time they made a report. So I think that just the fact that that came out and there was a public reaction against it, they did something about it. And so
Yeah,
to some extent that the pressure from exposing the situation does something, but
I think that's right. I think there's a lot of good litigation attorneys who over the last, when mandamus has become quite popular and for good reason. And so the information that comes out of some of these lawsuits, it's almost as if, the agency's dirty laundry is being hung out, and judges are, it becomes a much bigger policy issue, especially when some of these suits get media attention. And I agree, Suzanne. I think that's and the hope is that attorneys and everyone just keeps advocating and suing, and when there's and pursuing pursuing good litigation when it makes sense to do so, and making the government respond and do its job. And
Ishan, what did the lobbyists say when you were talking about this, and what can possibly be done via lobbying?
So of course, via lobbying, which is legislative solutions such as visa recapture and all of that, of course, can be done. But the biggest thing I think we can do in the short term, if we gather and raise enough funds for our lobbying efforts, is to speed up the processing at the consulates, because that is a rampant problem for everyone, regardless of which country or which consulate you're going through. NVC, the consulates, they aren't moving quickly enough to go handle the visa interviews, issue the visas, and go forward with it. Our lobbyist feels that the folks who work essentially in the foreign service, they do not like to be seen as, do not like for others to see them as incompetent. So they don't behave the way that, say, USCIS does. So if we are able to highlight this issue and able to advocate for it, and get in front of the State Department, we think we can really solve this one big pain point, at least in the short term. That will help alleviate that. As far as USCIS processing of petitions goes, that's going to be a longer, more legislative process that will that will take time, just like visa recapture will. But it is possible. These are all doable things. For example, when we look at the fee structure and look at the increase in fees and see how it's going to be spent, we can ask for justification for these increase in fees and perhaps even get estimations or set expectations for how long the average processing time should be decreased down to. So here's hoping for that.
I just wanted to make the point that there's no excuse for the fact that it takes 6 months, because again, I get notified by NVC when there's an I-130, and I'm sure, Dennis, you have this experience. When an I-130, which is another, immigrant-based petition, it's the family one, gets approved, I often get notified by NVC about the approval before I even, get anything from USCIS about the approval. It's instantaneous. Meanwhile, with USCIS, I have to submit more with IPO service requests, asking for them to notify NVC of this approval just to get it sent. 6 months is about right, because they don't care. It is negligence at worst, and probably more than negligence. It's deliberate. And that's just, I have a case that has been sitting, and the clients have to file mandamus, that has been sitting because USCIS claims they didn't receive the response to an RFE that they denied. We reopened it. We even sent it. They acknowledged. It has now been a year since they received the response to the RFE that was 35 pounds. That's how big the physical filing on this case, and they still haven't adjudicated the response to the RFE. Right? This is IPO. This is what we deal with on a daily basis as attorneys, and our clients deal with because they are the petitioners. So it is a division-wide issue that is going on at the IPO, and it has been for years. And so it's so frustrating, and it just seems to be getting worse, never better. And they want more money. So what? I've been in this industry since 2007. I have never seen it get better. And every time they say we need more money to get more adjudicators so we become more efficient. I mean, you've heard me, Sean, talk about this. They don't. They never get more efficient. They hire more people, they get more money, and they get worse. Processing times get worse.